it further gives credence to the fact that the courts have become very partisan or highly politicized. And I think that the Supreme Court judges missed a very golden opportunity to contribute to a rich jurisprudence. They missed everything and every opportunity they could ever have to contribute to consolidating our democratic gains. And of course, they are not just the ones missing the opportunity. Every democratic gain under this government has been eroded. And I agree with the Honorable Asiedin Kritia when he says that our members of parliament should not attend parliament. At least per the constitutional provision, they have up to about 15 times to absent themselves. Between now and the election, parliament cannot sit within 15 times. So they will not have been breaching any constitutional provision. But if you've monitored why we say that this decision should not come from the Supreme Court, we cannot even forgive the High Court if they make this error. So it is even more worrying, and it shows you some levels.
Error as in the ruling?
Yes.
Okay.
It's an error fundamental that if it was not because the Supreme Court gave it, any lawyer will go to court for a certiorari to quash, not challenge,
to quash it.
To quash the decision, because it does not have legs in law to stand with. And I'm very scandalized. I've been reading the 109 page. I read it on Friday, I read it on Saturday, I read it yesterday, thinking that something by some miraculous means would change. And I could see the struggle of Justice Asaridaku. You know, for me, I feel the pain to criticize Justice Asaridaku because I've appeared before him a number of times when he was in the commercial court. And he was very nice to me, and he was very magnanimous in granting me some of my applications. I think my biggest, maybe my second biggest case, he granted me a certain application. But on this constitutional law matter, he got it absolutely wrong. You see, law is not customary arbitration, where you just appear before chiefs and they listen to the side of the story and they say that, okay, Annie, you are right and Beatrice is wrong. Law is such that it is structured in the way that people have to be trained to be lawyers before they can represent. It is in modern times that we are trying to change, or when you represent yourself, then we relax the rules because we appreciate that you don't understand. And the fundamental principle is that everything goes to jurisdiction. So if a court does not have jurisdiction, the court cannot decide on the merits of the case, even if the outcome of the case or the outcome of the decision of the court is correct. And that is why when you have a case, I keep saying that, Annie, you cannot write a letter and take the letter to the court because your case is a very sad one. And that is why you cannot just stand up and go to the High Court when the matter has to go to the district court, because we say that the court must assume jurisdiction first before they decide on the matter. Now, what are we saying? The issue of jurisdiction, like capacity, and it's so important that the law says that you ought to be able to raise the matter of jurisdiction anytime, even after judgment and on appeal, because when the court does not have jurisdiction, it matters not what the outcome of the decision is. And so it's not as if the NDC or many other legal minds who have said that this decision, including the Justice Atuguba, who have said that this decision is wrong in law, it's not because we just want to criticize the courts for criticizing the court. And so far, you have not even heard people arguing so much about the merits, because to the extent that they got the basis wrong, everything they build on it is wrong. Justice Denning says you cannot build something on nothing. That has been the legal principle. Now, let me say that the Supreme Court has 3 different jurisdictions. They have what we call the original jurisdiction. They have what we call the appellate jurisdiction. And then they have the reference jurisdiction. So, we are not saying that the Supreme Court does not have jurisdiction to interpret a constitutional provision. That's not what we are saying. We are saying that you have original jurisdiction, you have appellate jurisdiction, and you have reference jurisdiction. And all these jurisdictions have been conferred for a reason. They are not for aesthetics reasons. They are because law is structured in a certain way to bring some level of predictability. So when the Supreme Court takes a reference jurisdiction and assumes it as an original jurisdiction, it is very problematic. And especially when that intention is to aid the executive to do something.
Not necessarily.
But what is it?
It was not to aid anybody.
I will demonstrate to you why it was to aid the executive.
I mean, you can criticize on the
I'm saying that it was to aid the executive, and I'll demonstrate to you. First of all, the court in itself admitted that the matters which is before it, it's matters which should have been at the High Court. Mm-hmm. However, they are saying that because it's a pure question of law, and I'll demonstrate to you why the Supreme Court was just seeking justification, and for that matter, a loose one at that. Annie, let me show to you. You know why, Annie, you cannot go to court to ask for a declaration that the Supreme Court should order the dollar to move from 4 cedis, to move from 17 cedis to 4 cedis, because on a true and proper interpretations of whether the directive principle of state of this country, of the 1992 Constitution, it is unconscionable that the dollar will be selling at 17 cedis instead of 4 cedis. Don't you think so? Mm-hmm. Don't you think you should be able to go to court and ask the court and to compel Dr. Baumia as head of the economic management team to make sure that he indeed arrests the dollar and brings it to 4 cedis? When you go to court, although you have in your writ that on a true and proper interpretation, or on a true and proper interpretation of the provisions of the directive principle of state policy, Ghanaians ought not to be buying the dollar at 17 cedis, and that an order should be made for the dollar to be purchased at 4 cedis. You know why you can't do that? Or even if you did that, the Supreme Court will look at it and say that this is not a matter for constitutional interpretation. So the courts have said in many Supreme Court decisions that when a matter is brought before you, the court must first examine whether it has jurisdiction or not, even if the parties themselves did not raise it. Now, on page 14 of the judgment, this is what the majority opinion reads. The suit essentially hinges on a pure question of law, specifically the proper construction of Article 97(1) G and H to establish a legal threshold for triggering its provision without delving into factual disputes regarding seat vacation in Parliament, which properly lies within the purview of the High Court and Article 99 of the Constitution. You see, this the Supreme Court got purely wrong. This suit does not hinge on a pure question of law, because when you look at the release being sought by Afenyo Markins, he was not asking for just a declaration on the true and proper interpretation of Article 97(1) G and H. That's not what he was asking. He was asking that by reason of Article 97(1) G and H, a declaration should be made that Andrew Esiamwa Amwako, Cynthia Mamle, and Kojo Asante are not, or their seats have not become vacant. So this suit is not purely a question of law, as the Supreme Court wants us to believe. It's a question of fact, which the applicant or the plaintiff himself has pleaded or asked for a declaration. So first of all, they cannot run away and say that, oh, it is not the factual basis that Afenyomakin is asking us. It's a pure question of law. So that should tell you that where the court was going, they did not have jurisdiction. Then the second thing, the court copiously took solace in cases like the Jachikwesion's case and the Zinato case and said that a similar instance happened in the Zinato case. And so we are justified in assuming jurisdiction. Nothing like that happened in the Zinato case. Why? Are we all not in this country? The cases are reported. The Zinato case started at the High Court. Yeah. The High Court judge, Justice Akabuafo, another very good judge that has been kind to me. Justice Akabuafo sought to say that a certain provision of the Constitution was not ambiguous and went ahead to interpret same. And then Zenato's lawyer said that you do not have the jurisdiction to interpret the Constitution. And by reason of Article 131, when a matter arises which has to do with a constitutional matter in a high court, you must refer it. And so they filed what we call a certiorari application at the Supreme Court. So the Supreme Court quashed the decision of Akabuafo and now said that we have now assumed jurisdiction to interpret the said provision. After interpreting the said provision, they did not make any declaration whether or not Zenato was qualified or not. They said that we are remitting the matter back to the High Court because when it comes to issues of eligibility, the Constitution says that it is the High Court that is the right forum. And so that point has to be made. But you know one thing that the Supreme Court did? Do you know that in the entire judgment of the Supreme Court, they did not declare that the seat of the NDC MP has become vacant? They didn't go there. The Supreme Court, they were just minded about the MPP seats. And so there is no declaration that Peter Yaokwachi Aka, his seat has become vacant or otherwise. We can only but imply. So where is the interest of the court? They are so interested in the MPP seats. But some way, somehow, they are not interested. Why? You know why? Afenyomakin did not ask for that declaration. And so that is why I'm telling the Supreme Court that it cannot be a mere matter of law. Because these facts were pleaded. I mean, some of them were not even pleaded. Now, the Supreme Court did something very funny. When you look at page 10, because the Supreme Court knows that, and this is where it gets very murkier, because the Supreme Court knows that, page 10
of the ruling,
of the judgment.
I'll forward the judgment to you, so just in case you want to.
Because the Supreme Court knows that they did not have jurisdiction, you know what they did? They said that in the second paragraph, the resolution of the jurisdictional question of facts in this instant case involves first determining whether the act or conduct complained of against the first defendant falls within the purview of our jurisdiction. And this is where you cannot convince any reasonable mind that the Supreme Court was not being political.
Page 10, which paragraph?
The second paragraph. The resolution of the jurisdictional question. They are saying that before they can determine the jurisdictional question, they have to look at the conduct of the speaker. I mean, before the case was put before the Supreme Court, the speaker had not done anything.
Yes, I remember.
In fact, even after the speaker's act or the breach which they complain of had occurred, the plaintiff did not go back to the court to say that this is what has happened. So we are wondering, how did the Supreme Court come to the knowledge of the fact that this has happened? Because you know the Supreme Court, like I've told you, is not customary arbitration. It's a court of record. So you cannot just go there and say that Mr. Speaker has done this. So it's either the Supreme Court people, for me, either they were watching TV or they were watching the proceedings of Parliament, or they probably call someone to ask what happened. I've heard some senior lawyers justify.
Or they picked intel.
That it is something we call judicial notice, that the court can take notice of things which are happening.
And predict.
No, and say that we acknowledge this thing is happening. Okay. And so based on that, we'll make our decision. That judicial notice cannot be taken in a vacuum. First of all, it is a matter of evidence when you are determining the evidence on record that you have to take judicial notice. And even if you were taking judicial notice, there must be things which are so accepted and incontrovertible. For instance, Akan's name Kojo. Those are things you can take judicial notice of. That, Akan's name Kojo or Gan's name Namomo. Those ones are not contested, no side, no reasonable mind. But you cannot take judicial notice of things which are highly controversial and which are being disputed and which is even a matter before you for determination.
Like what happened in Parliament.
Like what happened in Parliament. So it tells you that the Supreme Court had a certain outcome. We just don't want to declare the seat vacant. But how do we justify that? We must find a reason in law.